2 men were killed over just $2. And now a teenager who confessed while high is set to face execution this May. But don't skip ahead, because later we'll get into a shocking new case involving a 6-year-old at the center of a 2026 legal fight. And the reason behind it points to a loophole that could change how the system treats minors completely. On a night in 2008, 2 teenagers boarded a DART train headed for Garland, Texas. James Broadnax and his cousin, Demarius Cummings, both 19, told investigators they were planning to rob somebody. They said they took the DART train to Garland to target rich white folks. Their destination was a recording studio, a place that produced Christian music, not the kind of target most people would associate with a robbery. The men they encountered turned out to be singer Matthew Butler, a father of 2, and Stephen Swan, his employee, outside Butler's Christian recording studio, Zion Gate Records. What happened next ended 2 lives and set a third on a collision course with the Texas death chamber. Broadnax was sent to death row for robbing and killing Stephen Swan, 26, and Matthew Butler, 28, in the Dallas suburbs in 2008. The robbery itself was almost absurdly futile. Broadnax and his cousin, Demarius Cummings, had set out to rob the men, but left with only $2 and a 1995 Ford, according to previous reporting from the Dallas Morning News. $2 and a car. That was the haul. 2 men lay dead outside a recording studio for the sum total of $2. Broadnax and Cummings, both 19 at the time of the robbery, were convicted of capital murder in separate trials. But from the very beginning, there was a massive divergence in the punishment. Broadnax, who was tried as the triggerman, was sentenced to death, while Cummings, who was tried as his accomplice, was sentenced to life in prison without the possibility of parole. Broadnax was 20 when he was sentenced to death in 2009. He was a teenager when the crime happened. He had no prior criminal history to speak of. Cummings said he had already been convicted of other offenses, including burglaries, while Broadnax had a single charge for marijuana possession. So here you have the younger cousin, the one with essentially a clean record, sitting on death row, while the older cousin with the extensive criminal history serves life. And that disparity is at the heart of everything that has unfolded over the last 17 years. The initial case against Broadnax rested on one central pillar, a confession. The prosecution relied on statements made by young Broadnax during an interrogation conducted shortly after his arrest, before he had been psychiatrically stabilized, placed on medication, or subjected to suicide prevention measures. At the time, he was experiencing severe mental distress, was under the influence of PCP, a powerful dissociative and hallucinogenic drug, and he informed jail guards that he had suicidal tendencies, hallucinations, and was hearing strange noises. The confession was deemed reliable despite Broadnax's documented mental illness and his young age. That confession became the bedrock of the state's case. Broadnax, who did the shooting, expressed no remorse in his interview after the arrests. Those media interviews, given in the hours after his arrest while he was still under the influence, would haunt him for the next 2 decades. They were played for a jury, they were cited by judges, and they formed the backbone of an argument that this 19-year-old deserved to die. If the confession was the state's strongest weapon, the DNA evidence should have been the defense's. But the story of how that evidence was handled, and ultimately sidelined, reveals the mechanics of a capital trial where science took a back seat. The forensic DNA testing in this case involved a thorough analysis of the firearm, the victim's clothing, and other items using DNA typing. The results excluded James Broadnax from the key evidentiary samples, both from the right grip of the firearm and the trigger, and his DNA was also excluded from the victim's pockets and clothing. Let that sink in for a moment. The man convicted as the triggerman, the man who allegedly held the gun and fired lethal rounds into 2 human beings, left no DNA on the weapon itself. DNA from only Cummings, not Broadnax, was found on the grip of the murder weapon, and in the pocket of one of the victims. Broadnax's DNA was absent from both. This is enormously significant. The only instance in which James Broadnax was not excluded concerns a low-level mixed DNA sample found on a shoe, but this does not indicate when or how the DNA was deposited. A low-level mixed sample on a shoe, which could have been deposited at any point, given that the 2 cousins lived in close proximity, was the only forensic thread tying Broadnax to the physical evidence at the crime scene. Overall, the DNA evidence does not place James Broadnax in possession of the weapon, or in direct physical contact with the victim during the crime. Instead, it weakens the guilty verdict by excluding him from the most important forensic evidence. But at trial, the prosecution had something else in its arsenal: something that went beyond ballistics reports and blood spatter analysis. They turned to the defendant's own creative output. The state introduced over 40 pages of his handwritten rap lyrics, characterized them as gangster rap, and argued to the jury that the lyrics constituted Mr. Broadnax's self-admission of his criminal mentality. To transform artistic expression into a death warrant, the jury was not presented with those lyrics as art. They were presented as a blueprint for violence, a manifesto of future danger. And this was not a side note in the trial. During deliberation, the jury specifically asked to see the rap lyrics twice, before returning a death sentence that same day. The lyrics weren't background material. They were the deciding factor. The jury asked to review them, not the DNA evidence, not the forensic reports, twice, and then returned with a death sentence. The issue of race in the Broadnax case is not a footnote. It is structural. It runs from the jury box to the prosecutor's spreadsheet to the closing arguments delivered in open court. According to James Broadnax's legal team, prosecutors tracked jurors by race during selection and struck nearly every eligible black juror from the panel. According to the Supreme Court case, Broadnax was convicted by an almost all-white jury. After the state struck every eligible black juror during jury selection, the trial judge added one black juror back to avoid impaneling an all-white jury. Documents subsequently disclosed by the Dallas County District Attorney's Office revealed that prosecutors maintained a spreadsheet tracking every juror by race and sex. Metadata associated with the electronic version of the spreadsheet confirmed that it had been created, used, modified, and printed by the state during jury selection. This is not speculation. This is documented. The prosecution kept a spreadsheet tracking jurors by race. They struck black jurors systematically. The trial judge had to intervene to put even one black juror on the panel, not because the defense asked, but because impaneling an all-white jury would have been too obvious. Then came the closing arguments. The state explicitly called Mr. Broadnax a new breed and a monster, like predators on Animal Planet, chomping at the bit to engage in violence. Language like that, calling a black defendant a new breed of predator, is not race-neutral prosecutorial rhetoric. It is the kind of language that activates deep-seated racial bias, especially before a jury that was deliberately assembled to be almost entirely white. Broadnax, who is black, alleged in Supreme Court filings that prosecutors using his lyrics as evidence in the sentencing phase of his trial and characterizing the music as gangster rap was racially biased. The issue attracted support from rappers like Young Thug and Travis Scott, the latter of whom wrote in an amicus brief that lyrics in the genre shouldn't always be interpreted literally. The case drew attention not just from legal scholars, but from the music industry itself. A broader coalition brief also drew support from entertainers, including Young Thug, T.I., Killer Mike, Anthony Anderson, and Kevin Liles. These artists argued that treating rap lyrics as confessional evidence is a fundamentally flawed approach that criminalizes an entire art form, one disproportionately created by Black Americans. For 17 years, the story stayed the same. Broadnax was the shooter. Cummings was the accomplice. Then, in early 2026, everything changed. The most recent development in the Broadnax case arrived on March 11, 2026. Demarius Cummings, Broadnax's cousin and co-defendant, signed a sworn declaration under penalty of perjury, admitting that he, not Broadnax, was the one who shot and killed Swan and Butler. The confession was not made casually. It was a formal legal instrument, signed under oath, carrying the penalty of perjury. Cummings stated, "When his lawyer told me on February 20th that James was scheduled to be executed on April 30th, 2026, I decided it was time to come clean, and I told him that it was me, and not James, who had shot the two victims." He said both of them were high on PCP and marijuana, and that he convinced his 19-year-old cousin to take the blame. The reasoning, according to Cummings, was cold and calculated. Cummings wrote that he persuaded his cousin to take the blame based on the circumstances of their criminal records. Cummings said he had already been convicted of other offenses, including burglaries, while Broadnax had a single charge for marijuana possession. The logic, as twisted as it was, held a grim internal consistency. Cummings figured that since Broadnax had a clean record, he would get a lighter sentence. A 19-year-old with no criminal history and a PCP-addled mind agreed. And then the state sought death. "I want to clear my conscience and do not want James to be executed for shooting two people when I was the one who committed those acts," Cummings wrote. through his own trial, Broadnax's trial, and multiple meetings with Broadnax's lead attorney, Stephen Herzog. It was only after he learned in February 2026 that his cousin was scheduled to be executed that Cummings broke. His attorneys told the defender that Cummings went through a spiritual evolution in prison and that his initial testimonies weighed heavily on him. And here's the part that should make anyone sit up straight. The confession is corroborated by DNA evidence that was present at Broadnax's original trial, but never fully explained. DNA from only Cummings, not Broadnax, was found on the grip of the murder weapon and in the pocket of one of the victims. Broadnax's DNA was absent from both, so the cousin says he was the shooter. The DNA says the cousin handled the weapon, and the man on death row is the one whose DNA was nowhere near the gun. Despite the confession, despite the DNA, the legal system has closed its doors one by one. Cummings' confession was initially raised in a petition to the Texas Court of Criminal Appeals, which rejected Broadnax's claims April 7th without reviewing them, saying his lawyers should have raised them in an earlier appeal. A concurring opinion by Judge Gina Parker said, although Cummings had confessed to the killings, Broadnax has not recanted his own confession in the 16 years since his conviction. This is a critical legal distinction. The court did not say the confession lacked merit. The court said it came too late, procedurally speaking. Essentially, if you do not raise an issue during a specific window, you lose the right to raise it later, regardless of how compelling the new evidence is. The U.S. Supreme Court on Monday denied 2 appeals from Dallas County death row inmate James Broadnax. 3 days ahead of his scheduled execution, Broadnax, 37, made 2 appeals to the Supreme Court. One, alleging the use of rap lyrics as evidence against Broadnax during trial was unconstitutional, and another arguing prosecutors struck black prospective jurors from the selection pool, resulting in a nearly all-white jury. Without comment, the High Court denied both. The Texas Board of Pardons and Paroles has denied clemency to James Broadnax, closing one of the final paths available to halt his Thursday execution. Clemency in Texas is historically rare for death row inmates, with only 3 cases since the penalty was reinstated in 1976. According to data tracked by the Death Penalty Information Center, the mothers of the 2 murdered men have their own position. Teresa Butler, Matthew's mom, spoke out on social media recently. Her public post read, "The defense is trying their Hail Mary pass, and it's all a lie. Don't believe that the latest fake confession, after 17 years, is going to change the cold-blooded killer's planned execution date. Their grief is real. Their desire for closure is real, and their belief that Broadnax is the killer has never wavered." Legal experts, however, have raised alarms. The system in Texas is incredibly broken when you have an actually innocent person headed towards an execution date, when the real killer has admitted to being the actual perpetrator, said Burke Butler, co-executive director of Texas Defender Service. Broadnax is 37. He's been tethered to death row since he was 20. Nearly half his life has been spent in a cell, waiting. Broadnax has been on death row for almost 17 years, and an execution date had never been set until December of last year. For 17 years, there was no date. Then, in December 2025, the machinery accelerated. The Broadnax case exists within a long and disturbing history of young people being executed in the United States. And to understand the weight of that history, you have to go back to a small town in South Carolina in 1944. George Junius Stinney Jr. was an African-American boy who was wrongfully executed at the age of 14 after being convicted during an unfair trial for the murders of 2 white girls in his hometown of Alkaloo, South Carolina. On a spring afternoon in 1944, George Stinney Jr., 14, and his little sister were grazing the family's cow near railroad tracks that separated black and white families in Alkaloo, South Carolina. 2 white girls, ages 11 and 7, stopped by to ask where they could find wildflowers called maypops. When George said he didn't know, the girls went on their way. The girls' bludgeoned bodies were found the next morning. What followed was the fastest journey from arrest to execution in modern American history. Accused of murdering 2 white girls without a shred of physical evidence, George Stinney Jr. was charged, tried, convicted, and executed in a span of just 83 days. Deputy sheriffs came to the Stinney home, handcuffed George, and took him away. They questioned him for hours without his parents or a lawyer present, and claimed the black boy had confessed to killing the white girls. No written or oral confession. No evidence of any kind against young George was produced. It is reported that the police offered him ice cream to coerce a confession out of the young Stinney. George's father was fired from his job at the sawmill that night. Amid threats of a white mob, the family was forced to flee town. On March 26th, a white mob attempted to lynch Mr. Stinney, but failed to do so only because he had already been moved to a jail in a different town. The trial was a mockery of justice in every conceivable way. As was typical at the time, Stinney was tried before an all-white jury. After deliberating for less than 10 minutes, the jury found Stinney guilty of murder. The trial lasted 2 hours. The jury, all 12 jurors, were white in a county that was almost 3/4 black, convicted George after deliberating for 10 minutes. The judge sentenced him to death that day. Mr. Stinney's attorney had no experience representing capital defendants and failed to call any witnesses in his defense. There is no transcript of the trial and no appeal was filed by Stinney's counsel. No transcript, no defense witnesses, no appeal. A 14-year-old boy was sentenced to die, and there was not even a record of the proceeding that condemned him. The execution of George Stinney Jr. took place on June 16, 1944, at the South Carolina Penitentiary in Columbia. The young boy went into the execution chamber holding a Bible. Court records show that he was 5'1" and 95 pounds, and accounts state that he had to sit on a stack of books to be tall enough for the electric chair, a stack of books, because the apparatus of state execution was designed for adults, and this was a child. According to witnesses of the execution, the initial electric charge caused Stinney's mask to fall off, exposing the pure agony on his face as tears rolled down. Other accounts add that saliva emanated from his mouth. Purportedly, the first jolt did not kill him, and the executioner had to try twice before George Stinney Jr. was pronounced dead. It took 70 years for the legal system to acknowledge the obvious. A re-examination of Stinney's case began in 2004, and several individuals and the Northeastern University School of Law sought a judicial review. Stinney's murder conviction was vacated in 2014, with a South Carolina court ruling that he had not received a fair trial and was thus wrongfully executed. George Stinney was not an anomaly. He was an extreme example of a system that treated young black defendants as disposable. The death penalty for juveniles in the United States was first applied in 1642, before the 1972 Furman v. Georgia ruling that instituted a death penalty moratorium nationwide. There were approximately 343 executions of juveniles in the United States. Children who were sentenced to death and those who were executed in the U.S. were overwhelmingly poor, black, male, and residing in southern states. Legal scholar Victor L. Stribe's landmark 1987 study of American juvenile executions found that in a nation where black people have never comprised more than 15% of the population, 69% of people executed for crimes committed before they turned 18 were black. In the United States, capital punishment for juveniles existed until March 6, 2005, when the U.S. Supreme Court ruled it unconstitutional in Roper v. Simmons. That ruling came too late for many. In the years following the 1976 Gregg v. Georgia ruling that overturned Furman and upheld the constitutionality of the death penalty, there were 22 executions of juvenile offenders before the practice was outlawed. The youngest at the time of execution was Steve Edward Roach, who was 23. Even in the modern era, when the system took years to carry out sentences, the people being killed were often those who committed their crimes as teenagers. And there is one more case that completes the 2026 picture. Krista Gale Pike was just 18 when she lured a fellow classmate to a secluded area on the University of Tennessee agricultural campus in Knoxville, where the killing took place. She was convicted of first-degree murder in 1996 and became the youngest person on death row in the United States at age 20. In Tennessee, she was involved in the brutal torture and murder of 19-year-old Colleen Slemmer, whom she reportedly saw as a romantic rival, and later shocked classmates by allegedly showing them a fragment of the victim's skull. If Pike is executed on September 30, 2026, she would be the first woman to be executed in Tennessee in roughly 2 centuries. Her case is notable for how different it is from Broadnax's. Pike's guilt has never been seriously questioned, and on August 24, 2001, Pike, with alleged assistance from inmate Natasha Cornett, attacked and attempted to strangle fellow inmate Patricia Jones with a shoestring, and nearly succeeded in choking her to death. Her violence continued behind bars. Before November 2022, Pike had completely exhausted all appeals processes. Meanwhile, the victim's family has never stopped waiting. Colleen Slemmer's mother, May Martinez, told WBIR-TV in 2021, "My heart breaks every single day because I keep reliving it, and I can't no more. And I want this to happen before I die." The execution schedule for the coming months in the United States is packed. As of April 22, 2026, a total of 39 people are scheduled to be executed in the United States. All of these executions are scheduled over 4 calendar years in 7 U.S. states. The May 2026 schedule alone includes Raymond Johnson in Oklahoma on May 14th, Edward Busby in Texas on May 14th, Leroy McGill in Arizona on May 20, and Tony Carruthers in Tennessee on May 21st. Texas has executed 598 inmates since resuming capital punishment in 1982. While new death sentences have declined since the turn of the century, Texas has accounted for more than a third of all executions nationally in the same time frame, and more than the next 4 states combined. James Broadnax, 37 years old, convicted at 20, imprisoned since 19, sits in the Polunsky unit in Texas as his final hours tick down. His spokesperson said, "James continues to maintain faith and stoicism, and belief that his case will still have a chance to be heard and that his life will be spared. The facts of this case are what they are. 2 men are dead. A confession exists from the original defendant. A second confession, signed under oath 17 years later, names a different shooter. The DNA evidence aligns with the second confession, not the first. The jury that delivered the death sentence was assembled from a pool that was deliberately purged of black jurors. The penalty phase relied on rap lyrics treated as criminal evidence, and every court that has been asked to intervene has said no. Not because the claims lack merit, but because of procedural rules about when those claims should have been raised. Whether James Broadnax is executed or spared, the case lays bare the machinery that determines who lives and who dies in the American justice system. George Stinney was 14. Broadnax was 19. Krista Pike was 18. The question is not just about guilt or innocence. The question is whether a system that has gotten it wrong so many times before, that executed a child who had to sit on a stack of books to fit in the electric chair, can be trusted to get it right now. And right now, in 2026, nobody seems to have a good answer.